Welcome to the Estates Made Simple podcast with Jenna Carvalho and Gordon VanderLeek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome, everyone, to another episode of Estates Made Simple. Gord and I are excited to be here today to put Gord in the hot seat. Today, we are going to talk about common questions that we've received over the past year. And I, Jenna Carvalho, get to ask Gordon VanderLeek all the questions and put him in the hot seat. So we know, Gord, that you have no shortage of words. You like to explain everything in detail to make sure everyone understands really well.
Well, it goes back to the days when the lawyers got paid by the word. So it's just inherent in our profession that you talk longer, you make more money. But anyway.
So today I'm going to put some
limits. The teacher in me errs on the side of getting into too much detail. So I like what do we call them? Like when you go bowling with the kids, they have the bumper rails or something to avoid me getting into the gutter. We'll create those bumper guards to shorten answers to your insightful questions.
We're going to give you a 1-minute limit on each question to give our listeners just a little taste of the topics we're going to talk about. We do have episodes that are a little bit longer with respect to some of these questions, so the listeners can feel free to explore those. But today it's a quick summary, and we're going to see what it can provide in this short timeline.
All right, let's go.
First question, Gord. Why does an estate administration take so long?
There is the perception that it takes longer than what it should. First of all, historically, it may have been that probate took a long time, although since 2022, there have been improvements in the probate process that goes a little bit faster. But a lot of it depends ultimately on dealing with other agencies, whether it's banks, they just take a while to process things and to get you funds and to collect those funds. The payment of the bills is normally fairly quick. But the big one is Canada Revenue Agency. To do the final taxes, they take a while to send you a notice of assessment, and you got to do the final request for a clearance certificate. So when you're relying on the consent or the actions of another party, and it's the government of Canada, and they have a lot of work to do and not maybe enough people to do the work, there's a lot of delays in that. So that is usually the reason, assuming there's no complexity or litigation or other reasons why there may be delays, why the estate might go longer than what an average person might think. Oh, why can't I just wrap this up in a couple months? Because you got to go through this process and deal with Canada Revenue Agency ultimately, and that there's a process there you have to follow. You can't rush it. You may want to go fast, but they're going to take their time.
It's good for beneficiaries to really understand that as well. Great. So number 2. When does an executor typically charge fees to an estate administration?
The rule is they cannot do what they call pre-taking. They would get paid at the end of the administration of the estate. Now, there could be circumstances when they're substantially completed, they may make a request for compensation if it's approved by the executors or approved by the court, assuming a court application is required. If not, everybody's in agreement. Compensation might happen a little bit earlier than the end of the administration of the estate, but typically it's when the work is done, which sort of makes sense that the person has to do the work and then the beneficiaries will be in a position to judge the quality of that work. Are there any issues? Are there any concerns? How do you approve compensation ahead of time when you don't know if they're doing the job correctly? So it's always at the end of the administration of the estate, or it could certainly, from a practical point, be a scenario where the estate is substantially completed. If you're just waiting for the final clearance certificate, it's going to take 3 or 4 months. Maybe all the beneficiaries would agree, let's disperse, let's agree on the compensation, and it's fair now for the person to be paid for the work that they're doing. So it's not at the front end. It's not like you get a monthly payment. You got to do the work, and then the beneficiaries will be in a position to approve your proposal, or if there's not agreement, an application to the court will be made.
If I'm writing a will and I am appointing an executor, do I have to tell that executor that I've appointed them and ask their permission?
No, but you should. How's that for a qualified answer?
Love it.
The answer is no, because there's nothing in the law in Alberta, or even as I'm aware of it in other provinces, to obtain the consent ahead of time. But I think as we've talked about on other episodes, it's highly recommended, right? All you have to do is put yourself in that situation. What if you're named as an executor and suddenly you find out and it's a total surprise? In that situation, you might say no. It certainly probably doesn't feel great. So I always say if you're going to nominate somebody, that doesn't guarantee they're going to actually say yes. So you want to get to yes. And the way to do that is to ask the person if they're prepared to serve. If it's been a while since you asked them, you probably want to check in to say, do you still want to serve in that role? If your will is 10 years old and that's when you had the conversation, don't assume the person even remembers that they said yes, and you probably should check in with them again. But there's no obligation for them to serve in that role. They can renounce, they can say no. And certainly from an estate planning perspective, you don't want a legal document that nominates somebody who's not going to do the work. Then it's as if you don't have anybody appointed. And we get back into a scenario where maybe there's some uncertainty, delays, or increased costs to get the replacement person in. So you don't have to, but I always say you should. And I think it's highly advisable because there's potentially a bunch of bad things that are going to happen if you don't do it.
Where is the best place to store my estate documents?
I would answer that to say where it's safe and it's not going to get lost or destroyed. The corollary to that would be let your executor know where that is. Don't keep that a secret. So there's not a right or wrong. It could be that some people go, I'm going to leave it with the lawyer, although most lawyers are getting out of the business of holding original documents. I know we generally start with, we're going to return the documents to the client and suggest they put it in a place of safekeeping. So there's not a right or wrong answer, but you got to ensure that it's going to be in a safe place, because the rule is you have to submit the original to the court as part of the probate process. And if you can't find the original, there's a presumption that you revoked your will, that we can't find it because you ripped it up or destroyed it because you didn't want it to be applicable. But if it's been lost, you have to introduce evidence to say it was lost. It wasn't meant to be revoked. So you got an immediate hurdle to get over if you can't find that original will, which is going to add to costs on the estate and certainly delay. And in a contested estate, or one that has some difficulties or some friction between the beneficiaries, it could be a live issue that might take months to sort out with the courts and the attendant legal costs. So put it in a place that's safe and make sure your executor knows where that is.
How do you determine if an estate needs probate?
You'll need to go through probate if you need to confirm to anybody that you have the authority to manage estate assets. So typically, any property in a bank, for example, an investment account, your savings account, your checking account, would all be frozen when the bank learns of death, because they want to make sure they're going to hand that money over to the right person. And they do that through the probate process. The probate process is based on notice, that you have to notify everybody who has an interest in the estate that you're making that application. They have a right to contest that or to challenge that. But that court order is the authority to the world that you are the right person. You are the legal representative of the estate, and you've gone through this due process to notify everybody who has an interest in the estate. So banks, Canada Revenue Agency, other third parties know that they can deal with you. So a lot of times the necessity of going through probate is because you have to prove your authority, and the authority comes from that application process, which results in a court order. The other reason I would say it may be important is that if there's contention and you want to start a limitation period, there's 6 months from the date of the grant of probate where somebody can make a claim against the estate. So in some cases, we want to trigger a limitation period to be able to safely distribute assets if somebody does not make a claim, even if we don't need it for other reasons. But for the average estate, it's to prove their authority and to give them the necessary legal authority to take control of the assets and be able to do what they need to as part of the administration of the estate.
And what does probate cost in Alberta?
So the probate costs, there's a suggested fee guideline, which I know is under consideration now as to whether we should come up with a different set of rules as to what should executors charge and what should lawyers charge for going through probate. But if we look at what the government charges, that answer is simpler. It's $525. We are still the low probate jurisdiction in Canada. Many provinces have a percentage. For example, in BC, it's approximately 1.4% of the value of the property in BC that would be charged by the government for going through that probate process. But the most you're going to pay in Alberta is $525. But practically speaking, if people are serving in these roles, there's an executor appointed who's doing work, they're likely to claim compensation. So that would be the cost of going through. And there might be some legal and accounting costs that are there as well. But arguably, those are going to happen potentially if whether you go through probate or not. But those are the typical expenses you would see in an estate. Somebody would say, here's what I've collected, here's all the bills I've paid off. I had to pay this to the lawyer, which would include the fee to the government of the $525. I've paid this to the accountant. There may be some costs at the bank that have to be accounted for, and then any executor compensation. But the probate fees, thankfully, are still low. We don't have percentage probate fees in Alberta. That may change in the future, so our audience can stay tuned. If that were to happen, I'm sure that'll be for sure a podcast episode talking about changes in the probate rules. But that's the most you're going to pay in Alberta, which is significantly different than in other provinces.
So last question, Gord. If you could design the perfect executor and give them 3 or 4 characteristics that you think they would need to administer the perfect estate, what characteristics would they be?
I think what comes to mind immediately is somebody who's trustworthy. What I see on estates is there's lots of little decisions that have to be made that could never be contemplated by the person when they're drafting the will or in their lifetime. So I think you want somebody who has good character, in whom you trust, to carry out the terms of the will. Now, it's clear that if you have a will and you have a plan of distribution, the executor, even if they don't agree with it, can't change it. They're legally obligated to do that. But there's lots of opportunity to do things poorly. So I think you want somebody who's trustworthy because there's a big responsibility. Secondly, I would say you probably want to find somebody who has the time. We do see that sometimes people get thrown in the role and the estate goes longer than it should because the person simply doesn't have the time to spend and to do their core responsibilities. And I think those that have been through the role of executor will all say it was more work than I thought. It's a common refrain. Like it is a lot of work. So you got to find somebody who actually has the time, or it's going to delay the administration state or cause other problems. You might miss some deadlines or not file things when you need to if you simply don't have the time. The other comment I would make would be a good decision maker. If somebody is in that role, sometimes the choice is not clear and you have to make a decision and weigh the options and consider your alternatives and then make a choice. And if somebody is not a good decision maker, they're going to be like, oh, I don't know what to do. What about this? And what about this? And then they do nothing, which is almost worse than picking maybe what could be a wrong decision. So in many cases, good decision-making skills will avoid unnecessary delay in the estate. So somebody with good decision-making skills and that they're able to process, gather the information required, seek the help of professionals, and go forwards. I would say trustworthiness, they have the time to do it, and good decision-making skills would be my top 3. There's a host of other ones, but I think that covers a lot of ground in terms of if you have somebody who meets those criteria, I think that would be a good choice.
Well, that's great, Gord. Thanks for letting me ask you all these questions. And as I mentioned before, these are common questions that we've received and continue to receive. So we hope this sheds some light on some high-level topics. Please feel free to contact us for any further topic suggestions. We look forward to hearing and seeing from you next time. And please subscribe on wherever you listen to your favorite podcasts. Thank you very much. We'll see you next time.
Take care, everyone.